Okay. Well, you guys are getting your stuff ready, people, and out of backpacks and stuff. I just want to remind, next week is the midterm. Like I said, about 40 questions, multiple choice or true false. About half of those will be on this document, and the other half will be about the other stuff that we talked about throughout the semester. The exam questions cover things kind of in a lot of them are narrative fashion. So there's a scenario set up and then a question about how to apply that scenario. That's be your multiple guess answer. If it covers the B-101, it'll say the B-101 in accordance with the B-101, et cetera, et cetera. Open note, open book, but not open share with your friend and send text back and forth. So as you can imagine. As you know, also the end of the year, the winner, the person with the highest scores of the two exams together will win the $1,000 prize. But I want to make sure, just because if you didn't get a high score or whatever, you can still, or whatever score you get, as you remember from the first day of class, you can write up. So if you got a B, you can write yourself up to an A. A C, write yourself up to a B, whatever your grade is. And that, as a reminder, is a 3 to 5 page double-spaced line paper that will cover something about that we've talked about this semester for the first half. I'm a relatively easy grader on that because, as I said, I want you guys to enjoy this class. I want you to learn, and I don't want this class to be something that can detract from your grade point, because if you want to become a lawyer like me, great. But that's what law schools and taking law school exams about. You're here to study to become an architect, and I don't want a law class to cut you down on that for your grades. The only difference, the only caveat is if you got a B and you write up to an A, the points equivalent of an A doesn't translate to the award. So when you get to the end of the year, the award is based on your raw score as opposed to grades. So, and then the write-up on to write up your paper, if you want to go from a B to an A, I maybe look at it a little more critical than if you went from a C to a B. But still, I just think it's important just to spend, and really, if you think about a double line-spaced paper that's 3 to 5 pages, it only takes you a couple hours. It's not a lot of time. The other thing I will say, and this happens every single year, because I know how busy you guys are, but somebody gets a B or a C on the midterm, sends me a note, wants to write up, we decide on the topic, and then they don't write it. And then you get to your last week of school, and you're like, oh my God, I want to write that, and you have so many things to do, and a lot of people that I know have wanted to write up, but they just don't have the time. So my recommendation is, after you get your grade exams next week, if you feel like you want to write up, whatever it is, get it done in the first 2 weeks, because you just won't have time. And it really doesn't take that much time. And how you do it is just send me an email and say, I want to talk about the hierarchy of laws. And I may say, okay, give me a little more specifics, and we'll figure out a topic. So go back and look at the first 7 lectures, pick something. I want to talk about the sustainability project exhibits, from the B-101. And what do you want to talk about it? Why this or why that? So just pick something. I will help you refine that, and then write me up. It's pretty simple. And I think everybody should do it unless you got an A. I mean, why not? I'm thinking if there's anything else. So the exam will be next Monday, and then Wednesday, I understand you guys don't have class on Thursday, so a lot of people don't come downtown on Thursdays. I can't promise Tuesday, and I actually play hockey Tuesday night, so I don't want to have the pizza party and ruin my hockey night, sorry. So, but if we have to, we will. But if does next Wednesday work for you guys as far as coming over to the tower, and I feed you guys, you can bring whatever booze you want. I'm not allowed to bring booze for you guys, but I can feed you. So does that guy work for you guys next week? Okay. And what we'll do is I'll give you a little tour of my firm, and I think I still have in my office. I bring my portfolio that I did way back when I was in law school before computers and everything. People they seem interested in looking at that. And then we just go over the exam on a projector and go through the questions. Depending on how the questions come in, There have been times in the past where the collective mass have told me that my question was unfair, and I've thrown it out, or I've given everybody credit for it. So it's worth it for you guys to come at least for that if you feel like, oh my God, this didn't make sense. I can't believe you wrote it this way. And you got to remember, I write like a lawyer, and I sometimes forget you guys don't necessarily read like a lawyer, so that happens in questions. Sorry. So I'll send out an email for that. I'll get everybody's name on the security list for check-in at the Sears Tower, and we'll do that next Wednesday. All right, moving to the end of the B-101. We stopped last week at the end of Article 4, which is the architect's responsibility, so we'll continue on there. I know there's 13 provisions, but we'll get through the rest of this guaranteed in the time left. Article 5 talks about the owner's responsibilities. As you remember, basically in contracts, it's agreement between two parties, and both parties have to do something. The basic examples I always give is, I will pay you $25,000, you will design me my new single-family home. We both have an obligation. So, obviously in this document, we had Article 4, the architect's responsibilities. Article 5 is the owner's responsibilities. So, unless otherwise, so under 5.1, unless otherwise provided for in the agreement, the owner shall provide information in a timely manner regarding requirements for and limitations on the project. That makes sense. You got to tell them, as the owner, here's what you need, and here are my limitations. It could be budget, it could be project site, it could be scope of work, like what you want into the space, whether it's a 3-bedroom house, whether it's a 200-unit apartment complex, whatever it is. But you have to provide it as the owner, you have to provide it timely. The probably biggest collection of litigation in the construction industry that I deal with is on schedule loss, the cost for projects on the delays. And there can be delays from all different places. The owner can cause a delay under 5.1 if they fail to give the information timely. The architect can cause a delay because maybe the design wasn't being done timely. They weren't doing and turning things around. Or if there was a change and the architect had to change something, maybe there was a code change, maybe there was a scope change and the architect may have delayed in turning things around. The contractor can cause delays. Contractor can cause delays because they aren't building it timely. They can't get the materials timely. There could be a strike. There could be that. There could be outside influences, weather, as I said just now, strike. There's lots of outside influences. And as you start to figure out all these potential areas where a project can become delayed, that's where you realize the cost comes in. And we all read about, governmental projects are always delayed and everything else. And I think, I personally believe, and it would be nice, but that has to do with certain liabilities, for the architect, one of the things that the architect could really do in adding value to any project, I believe, is working interactively with the owner and the contractor to keep things on schedule. What my group does, what my construction law group at my firm is, we handle these large, massive projects. And our hallmark is getting in and burrowing into the project schedule, whether it's the beginning part, the design schedule, because the architects have to create a schedule for how long it's going to take them to do the design, or the construction schedule. And we do that to benefit the owner and to the project so things aren't delayed, because time is money. So it's important here, the AIA document here recognizes that it's not just the contractor delaying or the architect delaying, that sometimes it could be the owner, and the owner has to provide that information timely. And if they don't, and the project's delayed, and it costs more money, and the owner blames the architect or the contractor, they can point back to this provision and say, you have failed to provide your information timely. 5.2, the owner shall establish the owner's budget for the project. Remember we talked about in Article 3 and Article 4 about the cost of the work, and as the architect is designing things, they have to update their cost of the work at the end of schematic design, at the end of design development. At each end of their phases, the architect is responsible for updating their cost of the work, but that's all based on the owner's budget. That has to start from the very beginning. Okay. And then the owner also has an obligation to update its budget as the project goes through, and in case their budget changes. So if the owner realizes after the architect gives them a budget after the schematic design or design development that the owner's wish list is going to bust the owner's budget, the owner has to recognize if I weren't on my wish list, I got to revise my budget, or I have to inform the architect timely, let's pare back the scope so we can stay within my budget. So it makes a lot of sense. It's pretty simple, but again, as a contract, we write this down to make sure that the owner knows what they're supposed to do. And then if the owner significantly increases or decreases the owner's budget for the cost of the work, the owner shall notify the architect. And that makes sense too. If I can't afford it, I got to let the architect know this, and I got to let them know on time. And if I'm going to increase the budget, I got to let them know so they can design up to it. Now, I believe also in the document it certainly talks about it with the architect side and the architect's responsibilities for basic services. But if there's an increase or decrease in the budget, that may impact how much time the architect's allowed to spend on it, and so that may impact how much the architect's getting paid. Rarely in a decrease in budget will the architect's fee go down, but certainly if there's an increase in budget, which causes an increase in scope of work, the architect should normally get paid for more. They probably will get an increase in their design fee. So, 5.3, the owner shall identify a representative authorized to act on the owner's behalf. This goes back, it could be, single-family home, you're going to deal with the homeowner, the people, whether the family or whomever. But when you're dealing with corporations and businesses, which most of the construction out there is on that side of the world, there's a representative. That representative is going to be, obviously, since we talk about the term authorized, that representative is going to be an agent of the owner. And that's that single individual. And it helps to have, and that's why they have this here as an obligation to identify who that authorized representative is. So there's not too many people giving orders. You want to make sure you're communicating with the right person, the owner's rep. Sometimes the owner's rep is going to be a third party. The owner's going to say, you know what, my business is doing baked goods. You're going to build me a bakery. I know what kind of oven I want, but I don't know anything else about it. I'm going to hire an owner's representative. They are going to handle everything. You deal with my owner's representative. So it doesn't have to be somebody from the owner. It could be a third party who would act as the owner's agent for those communications. Any questions on that? Okay. 5.4. The owner shall furnish surveys to describe the physical characteristics, legal limitations, and utility locations of the site and the project, a written legal description of the site, and then it goes on talking about what all is in those surveys. That's, as we've, over the course of years of delineating obligations and roles in construction projects, typically it's the owner that comes to the architect and says, here's my project site, and I've got these surveys. I know where the gas lines are. I know where the electrical lines are. Here's the meets and bounds, which is the borders of the property line, so you don't go over and start digging and having the contractor digging holes in the neighbor's project or the neighbor's land. So that's been typically delegated to the owner to bring. And so here the AIA has just said, all right, well, let's put it in writing. Let's make sure that happens. Now, like any contract, you can change these obligations. I can say for all the work out that had a Navy pier, my owner representative said, Mike, I don't want to deal with any of this. I don't want to deal with this. So for the architect's agreement, they made the architect responsible for tracking down the survey and getting all this information. So we just crossed this provision out, and we removed it, and we stuck it in under the basic services. Architect can charge for those services, but traditionally the owner has to bring these things to the table. 5.5, another traditional obligation of the owner is the geotech. Geotech is to make sure that the soil samples, or the soil is proper. So the owner goes out and hires a geotech engineer. They do a bunch of soil borings. They find out if it's silty sand or if it's, if you're dealing into clay or if it's good packed, depending on how the land is. So that the engineer, the architect who's hiring an engineer to do the foundations, can make sure they have the proper type of foundations done to soil. So, again, the architect says, or the AIA documents say, this is a traditional role of the owner, so we're going to put it in writing and say they're going to do the borings. The owner shall provide the supplemental services designated as the owner's responsibility in Section 4.1.1. If you remember in looking at the actual AIA document, 4.1.1 is that chart that's got 25 or 30 different things. And the chart has the description of the service, civil engineering, lead, whatever else it may be, and all these services. And then there are two columns to the right of that. One column has the term architect on the top, and the other one says owner, and you just check the box to see who's responsible. So these supplemental services that are negotiated at the beginning of who's doing what, you will delineate. And so this provision, 5.6, says if that chart in 411 has a checkbox under the owner's side, the owner's responsible for providing those services. And that way there's not a fight later down the road where the owner says, wait a minute, I thought you were doing that. No, I thought you were doing it. No, well, let's look at 411 and see who was responsible. And if it is the owner, 5.6 make sure that they have to have done it. 5.7, this is new in the 2017s. If the owner identified a sustainable objective in Article 1, remember Article 1 was talking about the initial information, and we went through that whole discussion about what's in the sustainable projects exhibit. And if they do that, they select this sustainable objective. The owner shall fulfill its responsibilities as required under document E204, the sustainable projects exhibit. And we're not going to cover that exhibit. I'm not going to go through the provisions of that exhibit for the class this year. I'll talk about it a little bit more. And as the semester goes along, we get into some examples of how projects are run, and they throw some ideas out about it. But it's just another document that I don't think we need to spend a great deal of time on. But in that document itself, there are specific provisions that the owner has to fill out, specific provisions the design professional has to fill out, and specific provisions that the contractors have to fill out. So here it says, hey, you got to fill out what you need to fill out in the sustainable project exhibit, and to achieve your sustainable objective, there are certain responsibilities that are defined in that exhibit. So that's all it's referencing there. And it includes, one example is, if you want to get a LEED certified building, typically it's going to be the architect that's going to be submitting the forms to the LEED committee and filling all that information, but the owner has to provide information to the architect to fill out those forms. So that's something that they have to do under the sustainable objective. They have to give that information, and they have to give that timely. So. 5.8. The owner shall coordinate the services of its own consultant with the services provided by the architect. And it continues, the owner shall furnish copies of the scope of service of the contracts between the owner and the owner's consultants. And then at the end of this provision, the owner shall require that its consultants and contractors maintain insurance, including professional liability insurance, as appropriate to the services or work provided. So this one's a really good provision for architects. Now, when I typically represent owners, I modify this provision, and I take the word owner and coordinating the services, and I dump it back onto the architect. And I will recommend to my owner clients that I will pay that architect for that coordination services, because it kind of is more logical that the architect does that, in my opinion, because the architect is coordinating all the rest of its own drawings and its own subconsultants. However, as I also described, when the AIA documents are created and formed, there's a committee that sits, and sitting on the committee are architects and their lawyers, and owners and their lawyers, and contractors and subcontractors, and everybody kind of has their input. And here's one where the architect said, look, if you want to bring your own subconsultant, the example I think I've used here is the architect's retained to design a hotel, but the owner wants some specialty kitchen, and so they bring in their own specialty kitchen designer. And the architect says, if you want to bring in your specialty kitchen designer, that's great. I'm going to create the box of where that kitchen is going to go in. And they're going to have to tell me what they want in that box so I can design the connections of coming in or where that space will be. But I'm not going to be the one responsible for making sure they're doing it on time. I'm going to provide them the drawings with the box, providing them the information, and they need to match it up because I don't have a contract with them. I can't control them. You, the owner, have the contract with that kitchen designer. You have the control of them. So it's not fair, as me, the architect, who has no control over this other designer, I can't tell them what to do. I can't tell them when to do it. It's not fair that I have to coordinate their work to make sure that they're doing it right and timely. So the architects have a pretty good argument to say this should be the owner's obligation. As I said, I often shift it back, and I will pay the architect for that, and sometimes even give them certain authority to instruct my owner's consultant, because the architect is designing everything else but that box, and so that for the process of the project, it may make more sense. But here, the AIA says, this is all the owner's job. The owner has to coordinate that. And if the kitchen designer's drawings show up late, owner's fault. If the kitchen designers, where their connections are different than the information provided by the architect, that's the owner's fault. So that's what this says. And then furnish the copies of the scope of services, the owner has to say, well, here's my deal with the kitchen designer, and here's what they're going to do for me. I'm going to provide that to you, architect, so you understand what they're doing, and so you guys can start speaking and communicating in the same languages. And that last provision about insurance as well, the architect says, you're making me get insurance. I don't want to be the only one out there, because if something goes wrong, let's say there's a fire, and it may have started in the kitchen, but the people from the kitchen are saying it's because of the way you design the electrical connections. Well, there's going to be a big battle over that, and if the kitchen designer doesn't have insurance, well, then the parties that are injured are going to be focusing on the architect who does have insurance. And they're going to say, look, if you're making me get insurance, you got to make them get insurance so we can make sure we're all in the same level playing field if there's a dispute later down the road. 5.9, the owner shall furnish test inspections reports required by law of the contract documents. So that's just, if you need to have certain EPA tests, if you need to have any certain inspections by home builders or by the city or whatever, it's the owner's responsibility to do that. They have to make sure that those things are performed and that the owner pays for that. A lot of times, and this is, I think, also very fair, you don't know what all inspections may come down the pike, or you may not know what happens. Let's say that you find out that there's soils that may be contaminated, and the architect didn't build that into their bid. They didn't put that into their pricing. So they're like, I don't want to have to worry about guessing or figuring out. You, as an owner, may want to have more inspections or less inspections. We don't know what's coming up. So I want that all on your plate. You pay for it. You figure out how to organize it. We just make sure it gets done, and we work it into our schedule. 5.10, the owner shall furnish all legal, insurance, and accounting services, so they have to do whatever is responsible or necessary to make sure that the project is insured and the money's there and the accounting for the project is done properly. Then 5.11, the owner shall provide prompt written notice to the architect if the owner becomes aware of any fault or defect in the project, including errors, omissions, or inconsistencies in the architect's instruments of service. This last part of this sentence is actually another good provision for the architect. Basically, it's saying is if you're the owner and you figure out something's wrong, something's wrong in the project, could be a construction issue. You were the owner, was walking the site and saw something wrong. This is saying you got to tell the architect this. You can't keep the architect in the dark. You have to let them know what's going on. And the second one is you may actually have some understanding or knowledge, or maybe your owner's rep has understanding or knowledge, and you know that there's potentially something wrong with the architect's drawings. If you know that, and it says becomes aware, if the owner becomes aware, you have to tell the architect. You can't tuck it away and hold back and then later come back and say, oh, you should have fixed that, or I thought you would have fixed that. If you had some knowledge yourself, you're obligated to keep the architect out of being in the dark. Now, what interestingly enough is this language here, becomes aware, is a lot of times where litigation ensues. As the owner, what does that mean, becomes aware? Like, are the owners trained in the profession? Is the standard of care for an owner in understanding the design drawings the same as the standard of care for the architect? And as my two favorite words as a lawyer, that depends. Depends on how sophisticated the owner is. Depends on what the owner has retained. If the owner retains an outside consultant, and the outside consultant is hooked with the owner, and the outside consultant saw something wrong with the drawings, well, then the owner should have become aware. And that would be then saying, you as the owner had an obligation to relay that information with me. So sometimes, but sometimes you can make the argument, I'm just a school board. You're building me a school. I saw your drawings. Sure, they look nice. I don't know what they mean. So how could I know if I looked at this that your drawings were incorrect? I didn't become aware. And then they may say, yeah, but somebody on your board has a design degree. Well, just because they're on the board and maybe their undergraduate degree is in architecture doesn't mean that they actually became aware. So this is a place where discovery and litigation to see if the owner actually had some culpability in not notifying the architect of issues. So. 5.12, the owner shall include the architect in all communications to the contractor that relate to or affect the architect's services or professional responsibilities. This is also new in the 2017. So in the past, for decades and decades and decades, the architect was, as I think I've told you, was the conduit of the communication between the owner and the contractor. And the architect will still be, by and large, the principal conduit of information. The drawings themselves is the conduit of that information, and if the contractor has questions, the contractor will issue what's called an RFI, request for information, and it's the architect's responsibility to respond to that RFI. But the AIA has recognized that in the last 20 years or so, as owners become more sophisticated, as projects become more expensive, owners are going to hire reps, they're going to have somebody internal in their company that will understand this stuff, and the owners are going to start talking to the contractors directly. And the architects really can't do anything about that because the owner has a contract with the contractor. And so what litigation has come before this provision, and there'll still be litigation on this, is that maybe there's something wrong with the services of the architect or something going wrong with the project. Owner and contractor are talking about it. Architect doesn't know. Then the project goes south, whether it's a delay in schedule or whether the wall falls down, whatever it might be, and we sue the architect. And then the architect says, wait, I wasn't even involved in these conversations. And what happened was people would take the old AIA documents and say, yeah, but you're designated as the conduit information. You should have known of this information. The architect goes back and says, yeah, but how am I supposed to know when you guys are talking over here? How could I know? And the owner says, yeah, but it says here in the document you should have known, so I'm going to tag you for that. Well, the AIA says that's not fair. If you, contractor and owner, are going to be chatting outside of the presence of the architect, this provision says, shall include the architect in communications. You cannot. And if the owner fails to do that, the architect has insulation from liability. So, the provision goes on. The owner shall promptly notify the architect of substance of any direct communication between the owner and contractor, otherwise relating to the project. Communications by and between the owner's architect consultants shall be through the architect. So the last one says, hey, if anybody's talking to the architect's subconsultants, the civil engineer, the electrical engineer, mechanical engineer, architect still gets to coordinate that because it's their own people. But the other stuff says, hey, owner needs to tell you and needs to tell you quickly, promptly, so you aren't left in the dark. And that's a defense for damages. If there's a damage claim against the architect, it's a defense to that claim because you were kept out of that discussion if the owner has failed to abide by that. Any questions on that? Okay. 5.13. Before executing the contract for construction, the owner shall coordinate the architect's duties and responsibilities set forth in the contract for construction with the architect's services set forth in the agreement. And the owner shall provide the architect a copy of the executed agreement between the owner and contractor. So again, this is putting obligations on the owner for coordination to make sure that the architect knows when the contractor is showing up on site, what the plans are for, what the delivery schedule is going to be, because by now when we get into this part about ready to execute the contract for construction, your drawings, the design or the construction documents are well on their way. They may be even completely finished, and the the owner and the contractor are negotiating everything. But this is basically saying, hey, the owner and contractor are going to enter into a contract. And we want to make sure, the architect, want to make sure that what's spoken about of everybody's duties and obligation in the construction contract is consistent with what we have provisions here in the B-101. We want to make sure everybody's on the same page. Now, luckily, if we're using AIA documents, they are traditionally written to be consistent. If you're using the standard B-101 with no revisions and the standard A201 with no revisions, there's not going to be any worry or confusion of who's supposed to wear what hat. But most lawyers, because this is what we do, we modify things, we change things, we tweak them. So the B-101 between the owner and the architect may be tweaked. It may say, architect shall coordinate this, and architect shall coordinate that. And in the A201, you got to make sure the architect says, well, if I have all these obligations in my B-101, I got to look at the A201 between owner and contractor to make sure that these changes on one side have been properly translated into the changes in the other document. And that's just the basic statement saying it's the owner's responsibility, but the architect at least wants to take a look at that. Any questions on that? Okay. Skipping down to 5.15. Within 15 days after receipt of written request from the architect, the owner shall furnish the requested information as necessary and relevant for the architect to evaluate, give notice, to enforce lien rights. So lien rights, we haven't talked a lot about mechanics liens. We will second half of the semester. A mechanics lien is this super right that people in the construction or in the building industry can place on property. So owner owns, I'll just give a really simple example. I have a single family home. I have somebody come in and they're going to do my kitchen renovation. I have an architect that does services for that kitchen renovation. Contractor does work. Subcontractors do work. The architect hires an electrical engineer, and that's part of the fee for the electrical engineer. If I don't pay the architect, I have a contract with the architect, and the architect can sue me directly on the contract. But if I don't pay the architect's electrical engineer also doesn't get paid. Electrical engineer has no contract with me. Can't sue me under contract. It's not a tort. The failure to pay someone is not a tort. They weren't injured by a bodily injury. So the electrical engineer is like, I'm out. Well, how do I get my money? Same thing happens on the construction side. If I don't pay the contractor can sue me directly on contract, but all the subcontractors aren't getting paid, and they don't have a contract, they can't sue me. So going back well over 100 years, people understood and discovered that this was a problem. Subcontractors and subconsultants on the design side were getting stiff right and left. So they created what's called a mechanics lien. And a mechanics lien gives the third party, the party that doesn't have the contract with the owner of the land, a right to file a lien on the property. And then they can file a lawsuit to foreclose on that property. It is a very powerful tool. That's why I call it a super right, because it actually takes priority over virtually any other encumbrance on the property. So, single family home that I have, I didn't pay cash for it. I put a down payment and I got a loan. The bank has a mortgage. If I fail to pay the bank, as we all know, the bank's going to foreclose on me, and they're going to take my house and put me out in the street. And they have the first priority to that lawsuit. If I'm in debt and all the creditors are coming after me and everything else, the bank tags my house, forecloses on my mortgage, and they get the profits of the sale of my house first, on top of everybody else. And then all the creditors that I owe money to get their money, whatever's left over. But if you file a mechanics lien, it jumps over the mortgage. And so what happens is the contractor, or the subcontractor, and the subconsultants and everything else, and they go to foreclose, the bank jumps in, and the foreclosure happens, and the house is sold, and the money's divvied up. The first people that are paid are the lien holders, the mechanics lien holders. That's why it's called a super right. It jumps over everything else. It's a really powerful tool. Question?
You mentioned that the
Subcontractors, yeah.
Do they all have to gather around to do it, or is just one person?
It's a really good question. The question was, is if there's, let's say that let's say there's 12 subcontractors that haven't got paid on a project. Do they all have to do it at once, or is there some process? And the answer is there's a process. What happens is each subcontractor is required to file their own lien independently. By the way, all this discussion about mechanics lien is not on this exam, but I wanted to give you understanding for this piece. But it will be in the second part, but I just want to tell you there's no lien question on here, but it helps you to understand why this is important and everything else. So what happens is, subconsultant, electrician files a lien on the property. And what ends up also happening is all the subcontractors, they're talking to each other. Have you been paid? Have you been paid? Everybody knows what's going on a project site. They all know what's going on. So the plumber files its mechanics lien, and electrical guy files a mechanics lien, and the steel guy files a mechanics lien, and they all get filed. And they're actually recorded in Cook County against the recorder of deeds, and it actually goes on your title. If you did a title search, it'll say mechanics lien, mechanics lien, mechanics lien. The subcontractor by law, and there's a statute of the Mechanics Lien Act, is required to provide notice, and if they don't follow those notice provisions, their lien's invalid. So there's all these steps that each individual trade or engineer has to go through. Notice includes given to the owner and the contractor. And then the lien can sit there, because let's say I'm an electrician and I'm owed $1,000, but the steel guy's owed $50,000. I'm not going to file a lawsuit to foreclose for $1,000. I'm going to try to use that as leverage and have some discussions and get paid what I can on the. But the steel guy that's owed $50,000, they may file a lawsuit. So the steel guy files a lawsuit, and then what ends up happening is the electrician has to figure out whether they want to jump into that lawsuit. So it starts out individually. Everybody individually files their mechanics lien. But once the lawsuit happens, then everybody kind of has to make the decision, do I want to jump in? Because if they fail to jump in and the property's foreclosed, there may be no money left. So it becomes a group effort after a while, but in the beginning it's individuals. For example, we had when I was representing Navy Pier, we had a big dispute, and there was a bunch of liens filed because of problems that happened, in my opinion, by the contractor. But they said it was the owner, and we ended up resolving it, so it was nobody's fault. Legally, it was nobody's fault. But there was one lien filed. And then within 3 months, there was 25 people in the lawsuit, 25 different parties in the lawsuit. So it went from one party asking for a little bit of money, and then everybody joined in. And it was always really interesting because we would get to court, and every month or two you go for a status, and you appear in front of the judge, and the judge would put us at the end of the call. Like you have a slot for a half hour between 10 and 10:30. She's hearing everybody's cases, and we were always last because the courtroom would just en masse stand up, and there would be 30 lawyers stepping up in front of the judge, and we would be like crowding around to all talk. And since I represented Navy Pier, I get front and center, but it was always this huge group, and then the litigation lasted probably about a year and a half, and the group got smaller and smaller as people peeled off and got paid or settled or what have you. So anyway, what's important about this, going back to 5.15, 5.15, is that if there is information about the property, whether it's the property description, or if there's a change in the property status, or who owns it, or if there's other liens right, this says if the architect writes to the owner about this, the owner has to furnish the information. So the architect, remember I said everybody's talking on the construction project. Well, the architect gets some of the information, but not nearly as much as the trades. Plumbers working right next to the electrical guy. They're pulling conduit pulling stuff through the same area, So they're knowing what's happening. The architect is on the site maybe once a week, maybe once a month, it depends. So if there's buzz going and the architect kind of is like, well, I'm hearing something, and the architect writes a letter, written notice, then the owner has to respond to that and has to say, here's what's going on, to allow the architect to protect themselves and lien rights. This was not in the previous provision as well. This is something that's important because the courts have recognized, or the AIA, I would rather say, recognized that the architect should be protected for their lien rights. All right, Article 6, cost of the work. Any questions just on the owner's responsibilities? Great. All right, cost of the work. As you remember, when we were back in Article 3 and talking about and 3 and 4 about the architect and designing in accordance with the cost of the work, I pulled a couple of these provisions forward so you could read it. So we've seen these again, but just to go over. For purpose of the work of this agreement, cost of the work, capitalized C and W, so it's a defined term, shall be the total cost to the owner to construct all elements of the project designed or specified by the architect, and shall include the contractor's general condition costs. General conditions is, say, the contractor has a trailer on the project site, or a photocopy machine, or whatever. Those are the general conditions, extra costs that the contractor incurs. And the contractor's overhead and profit, whatever costs that they're paying for their project managers, part of their overhead, their salaries, and then the profit the contractor makes. That all goes in this defined world of the cost of work. It also includes reasonable value of labor's materials and otherwise furnished by the owner. So if the owner brings their own people in, the cost of work includes that. But then it also says, but it does not include the compensation of the architect. So if the architect's getting paid $50,000, you don't add that into the cost of the work. The design fee is not part of it. It does not include the cost of the property. If it's a $3 million property and you're building a $1 million home on top of it, the cost of work is still $1 million, not $4 million. Financing contingencies, costs for the loans, and all this other stuff, those are not included. So it's just basically what it's going to cost to build this thing, but not to design it and not to buy the land. And that's important because cost of the work here helps the architect in the budget, number one. And number two, the cost of the work is the same definition in the A201, which is the owner-contractor agreement. So everybody, once again, is on the same page. 6.2. The owner's budget for the cost of the work is provided in initial information. That was Article 1. and shall be adjusted throughout the project as required under sections 5.2, 6.4, and 6.5. So there's these provisions that say when the owner's budget has to be adjusted, and we already went through 1 and 5.2. Valuations of the owner's budget, cost of work, and the preliminary estimated cost of work and updated estimates shall be prepared by the architect, and they represent the architect's judgment as a design professional, not guarantee, not judgment as a cost estimator. It's their judgment as an architect. So this is creating a defined standard of care for the cost of the work budget. So owner comes to the architect and says, I need you to design me this house for $1 million. That's my budget. I need you to prepare your project based on that, and I want my cost of the work estimate updates at the end of schematic, design development, and construction documents so I know I remain on budget. And the architect does that. Like, oh, we're good. We're under $1 million. We're under $1 million. We're under $1 million in all three phases. And the drawings go out for bid, and they're at $1.5 million. And so the question then becomes in and says, did the architect blow their estimate? And was their judgment as a design professional proper? Is $1 million budget and it went to $1.5 million, did they go beyond their own standard of care? Probably, because that's a 50% increase. But if it was $1 million and went to $1.1 million, did they breach the contract there? Arguably not. It's only 10%. You never know what happens to that. But what they're saying here is that the judgment is as a design professional, and that's very important in their standard of care, whether litigation will ensue. Now, sometimes you'll see construction or architect contracts where the owner will change that and say that the estimate must be within a certain percentage, 5%, 10%. And if they fail to hit that percentage, the architect must redesign for free. So, and good rule of thumb, like I said, probably is either between 5 and 10%, and that happens. Other times, the architect says, I don't want to have anything to do with these cost of the work stuff. I'm striking it from the agreement. I'm not doing any project budgets and estimates because I don't want this. What's the judgment of design professional? What does that mean? They strike it. They take it completely out of the agreement, and the owner has to get their cost estimator. So the last part of this thing is, again, this kind of, I won't say completely get out of jail free card, but it's important for the architect. It says the architect cannot and does not warrant or represent, so these would be like guarantees, that the bids or negotiated prices will not vary from the budget of the cost of the work or from the estimate of the cost of the work or evaluation prepared by or agreed to by the architect. So it's basically saying, it's like, I'm going to do my best, but I'm not guaranteeing it. And in writing, I'm not guaranteeing it. So when I come back and it's not right at $1 million, $1 million one or $1.1 or 1.2, things can happen. Pricing can change. I mean, it took you guys a year to get us to this project from beginning to end. You didn't get me information, and the price of copper went up. The price of steel went up. Who knows what happened? So it's not a guarantee by the architect. It's a good provision for you guys. 6.3. In preparing the estimates for the cost of work, so does the architect, they shall be permitted to include contingencies for design, bidding, price escalation. So they can be permitted to include, so price escalation may go up. They may have to understand some of the trends. Determine what materials, equipment, component systems, and type of construction will be included in the contract documents. And recommend reasonable adjustments in the program or the scope of the project to include design alternates and necessary to adjust the estimated cost of the work to meet the owner's budget. So basically what this provision says, 6.3, is owner comes to you and says, I want you to do me my house. I want you to design my house. My budget's $1 million. And here's my laundry list of what I want. I want 5 bathrooms. I want 5 bedrooms. I want 5.5 bathrooms. I want this scale of kitchen appliances. I want blue slate stone tile in my basement. I want to have this beautiful stonework deck. I want to have shiplap in the kids' bedrooms. I want to have a stucco or a cedar shake outside, blah, 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 blah. And the architect looks at it and says, look, you're never going to do this. You're never going to be able to get all these things. So I'm going to make changes and recommendations to your program to meet your budget. Or I'm going to tell you that what you want and where the costs are going and the trends is going to go out of your budget or within your budget. So this is a kind of an encouragement, at the very least, to have dialogue between the owner and the architect about what the costs are, and giving the architect the leeway to be able to say, Mr. Owner or Mrs. Owner, your prices are going to go up you may be able to bid this project out right now at $1 million, but by the time we're ready, by the time we're there, it's going to be 1.3 because I understand what price escalation is. I see the trend, so you're not going to be in budget. It's to help protect the architect and keep the owner informed. And then the architect's work shall be done based on conceptual estimate techniques current. And then if the owner requires a detailed estimate of the cost of the work, the owner shall provide that detailed estimate, but they get paid as a supplemental service. So the architect may say, we can get it in for $1 million. And the owner says, yeah, but I want to see a breakdown. I want to see what your cost is for plumbing, for electrical, for lumber, for foundations. I want to see this broken down so I can figure that out. Or sometimes the owner will say to the architect, this is probably for a bigger project. Let's say you're doing that $10 million toy factory that I've used as an example. The owner says, how long is it going to take to build that? Well, it's going to take about 18 months. Okay, I want to see in your budget. I want to see how much I'll have to pay each month. So you get kind of what sometimes referred to in the industry as a burn rate. How much money I'm spending each month. How long it's going to take me to spend that $10 million. Is it going to be front-loaded, back-loaded, and everything else? If the architect is required to do all those things to give a detailed schedule, a month-to-month burn rate, or detailed by trade, they get paid as a supplemental service. A lot of times, owners didn't understand this. Like, yeah, you're supposed to give me a budget. And the owner may know what his budget looks like and what they thought, and then the architect gives a budget, and the owner says, well, this isn't what I want. I want detail. And the architect says, okay, well, pay me. And the owner says, why? Why should I pay you for this? Well, now it's in the provision. It says, because it says right here you have to pay me for the extra detail. 6.4, if through no fault of the architect, the procurement phase is not commenced within 90 days after the architect submits the construction documents to the owner, the cost of work shall be adjusted to reflect the changes in the general level of pricing in the applicable construction market. So as I said, at the end of each phase, schematic, design, development, construction documents, the architect is supposed to give a cost of the work. So we get to the end of that construction document phase, and the architect says, here's your $1 million house, and my cost of the work is within that. And the owner says, okay. And they go out, and the owner's having problems with financing. So they haven't sent the drawings out for bid. And the owner finally gets the bank to give them the loan, and it's 5 months down the road. And it goes out to bid, and the prices come in high. Maybe because of its building in the summer season. Maybe the local contractors are much more busy, so they're a captive market, and they can increase the prices. Whatever the reason is. This provision says, owner, if you're going out to bid, that's what the procurement phase is. If you're going out to bid, you got 90 days. If it's after 90 days, my estimate isn't good anymore. So you can't tag me if you took too long to do your job to say that I blew the budget. We're going to revise that budget after 90 days. I'm going to give you really what it should be given the market conditions, and then we'll go from there. 6.5. If at any time the architect's estimate of the cost of work exceeds the owner's budget, the architect shall make appropriate recommendations to the owner to adjust the project size, quality, or budget, and the owner shall cooperate with the architect. So you're the watchdog along the way, and you will know if that 5 bedrooms, 5.5 bath house at some point in time when we're hearing everything the owner wants to fill in the blanks with is going to bust the bank. So you have an obligation to tell that to the owner. And it says, so the architect shall make appropriate recommendations. You have to give them recommendations to get within the budget. And the owner shall cooperate with you. The cooperation is, if the architect says the budget's bust, cooperation goes in 2 ways, typically. Owner either increases its budget and says, keep designing what I've asked you, or when the recommendations are to get rid of a bedroom or get rid of the upgraded appliances or whatever it might be, the owner has to go with those design recommendations. What's not cooperating with is the owner says, no, this is what I want you to design. I know you can do it. Keep moving forward. By the way, my budget remains $1 million. That's not cooperating. And if the owner doesn't, again, the architect's not responsible for the budget bust. If the owner's budget for cost of the work at the conclusion is exceeded by the lowest bona fide or negotiated proposal, the owner shall. So let's say they go out to bid for three projects, or three contractors, and all three submit a bid. And the budget was $1 million, and the cost of the work estimate was $1 million, and the lowest one that comes in is $1.1 million. So that's what this provision. All of them are exceeded by the lowest bona fide bid. Then the owner shall either A, give permission to increase the budget, B, reauthorize the bidding, rebidding, and renegotiation, 3, terminate in accordance with Section 5. So actually terminate the architect. Like, we're done. We can't build this for what the project was, so we're going to terminate the architect. Revise the program scope, or the fifth one, implement any other mutual acceptable alternative. So it tells the owner this is what happens if the actual prices come in over what the original estimate and budget was. So. (6.7). Now, if the owner chooses to proceed under 6.6.4, so we'll go back to it quickly, and that's to revise the program scope or the quality, so they're going to change what's in the project, keep the budget the same, but change the design scope. The architect shall modify the construction documents, so the architect's got to go in and make those revisions, as necessary to comply with the owner's budget. The owner requires the architect to modify the construction documents because there's this bust, and it's due to market conditions that the architect could not reasonably anticipate, then the owner shall pay the architect. So if there was this spike in copper prices, or something happened, or maybe an act of God, think of it this way. Can you imagine if you were in Houston, and you had a house design, and you went out to bid, and then the hurricane hit, and the very next day, the prices for everything went through the roof because every contractor under the sun was working, and all the wood in the area was going to be used to rebuild, and your price for your house just probably went double value. So the architect could not have reasonably anticipated those prices to make sure that the project would be busted. And if the owner says, all right, I need to redesign, I still need this house, but I can't afford it in this market, so redesign it from the architect gets paid for that. They could not reasonably anticipate. But if it didn't something like that, something crazy didn't happen, or something that was not reasonably anticipated, the architect shall modify them, and they shall be without additional compensation. So there's two scenarios. Lowest bid is over the owner's budget and the architect's estimate of the cost of the work. Scenario A is the architect says, I'll redesign it, you need to pay me because there was no way I could have known we would bust. And here are the reasons why I couldn't know. Scenario B is, I will redesign it, and owner says, and you'll do it for free to redesign it because you should have known that it was going to be a bust. Okay? This happens more frequently than you imagine. And most of the time, the architects are pretty good with it. Did you have a question?
How do they determine someone should have known?
The reasonably anticipate question, that's often where litigation comes in. And so, in the scenario, my example with the hurricane, that's easy. Act of God, things like that just happen overnight or within a short period of time. Could be a strike. Could be a whole bunch of stuff that happens. You estimate this project and there's a strike at the shipyards, and so there's not drywall that's coming in from other countries or something to that effect. There's lots of stuff that you can point to. Where it gets a little more confusing and where litigation that can ensue is depending on earlier on in the agreement and the obligations of the architect making the cost estimates and the dialogue that happens, the owner may say that you should have known these trends were changing in the market. You are the expert in this industry. Or, I took this project that you designed for me, and I took it to two other architects after we blew the budget, and they both gave me an estimate just looking at your drawings. And you told me you could do this house for $1 million. You designed it for me. I took your exact drawings and I gave it to two other architects, and they said, there's no way that this house ever could have been done for less than $1.2 million. That's an argument that the owner's going to make that says two other architects practicing in the same community with the same set of skills on the same project would have estimated it differently. the standard of care is being now established by these two other practicing architects that this would have been a $1.2 million budget, as opposed to the architect saying it was just $1 million. So there's various ways that you can prove that. Sometimes the proof is not as clear if it's an act of God, not as clear when you're getting opinions of somebody else and you present that to a judge or jury. Does that make sense? Okay. Okay. Article 7, copyrights and licenses. Now, one of the things I talk about really in the beginning of this is this is actually a really powerful tool for architects in the industry. You own your drawings. And under the law, unless it specifically states that your services are owned by the owner, you will always own your drawings. So if you have no copyright provision in your agreement, if it's silent, you own the drawings. You own the intellectual properties in those, what they call here is the instruments of services. Now, there are certain elements of your drawings that are like standard details for a wall section or for a window connection or roofing or whatever that are, it's arguable that the architect owns those because everybody uses the same wall section detail or what have you. And when it becomes in the public area, it's not necessarily it's not original or anything else. But by and large, the design and the layout, you own that. Have I given you guys the example of the architect that I represented that had the reflected ceiling plan where we use that in court? Did I do that or not? Okay, I'll give you a quick on that. So why this is very powerful that the architect owns the instruments of service, they have the copyright in it, is so it's what's called intellectual property. Real property is tangible. There's personal property, my backpack here, that's personal property, your car is personal property. Real property is still tangible, it's your house. You can actually physically, touch it. Intellectual property, though, has similar property rights of you. Somebody can own it, but as in the title of the word, you can only own it up here. A patent is an intellectual property piece, a trademark. Like, what really is a trademark? We all know the word Coca-Cola is trademark, and nobody else can use that except for the Coca-Cola company. But what are you holding? Well, you're actually holding intellectually the property rights of that, so there's nothing tangible to touch. Same thing with copyrights and drawings. Your design, the expression, your original idea of expression, if you designed it, you own it, and nobody can use that. So in my example of what happened with me, this is many years ago, we represented a major lighting manufacturer, and they had their own design department. And they were working with an architect, and they were a sub-consultant to this architect, and they designed for this building a very unique reflected ceiling plan. And there was lots of work in electrical and everything else. And they wrote about $450,000 for their services. Project got stalled. There were some issues going on, et cetera, et cetera, et cetera. People weren't getting paid, including my client. He got into negotiations trying to get paid, trying to get the owner to pay them for the services. And ultimately, the owner didn't want to make payment and went out, but got money for the project to keep it going, and went out and retained another designer of lighting systems. That designer of lighting systems took the reflected ceiling plan that my client had created and copied it and put it onto the drawings that ultimately went to the city to be stamped and permitted and removed my client's information from the title block. But it was clearly the reflected ceiling plan designed by my client. Now, there was lots of other work that was performed by my client with respect to this project. The value of the designs for this reflected ceiling plan was not the full $450,000. It was lots of that $450,000 included shipments of lights and some other stuff. But my client was still owed that money. Project started. By the time we got retained, the project was well underway, and that's how my client ultimately found out. Is he got a set of the drawings, and he found out this is my reflected ceiling plan. So they had called the other people up and yeah, whatever. We're going to keep building, and we'll pay you later. So when they came to me, I looked at that, and I said, send me your originals. So I sent the originals, I read them side by side. Sure enough, it was the exact same thing. Now, the reflected ceiling plan wasn't anything outrageously unique, but it was unique enough. Because it had to be designed for the layout of that building. You couldn't take that reflected ceiling plan and put it in the same size of building right next door because it wouldn't have worked, where the walls were and everything else. So the argument was, my client owned a copyright in the design of that reflected ceiling plan. And while the value of that design services wasn't remotely close to the $450,000, we were able to go into court and get what's called a temporary restraining order. And the TRO said there can be no work on this building, or at least the construction, because these drawings potentially were copyrighted, or copyright infringement. So a TRO is kind of like the preliminary phase of a lawsuit. You're stopping everything, get a restraining order from continuing work, while then the rest of the lawsuit continues to go on to see if there was actually true infringement of the copyright. We got the TRO. My client was paid in 3 days because the entire construction project had to stop. All the electricians pulling the wires had to stop. Anybody working on that ever would have used any of the drawings, even though they may not have been working on the reflected ceiling at that time, it's just they were using drawings that had infringing copies in it. So the court said, project shut down, the whole thing. We got paid because time is money. So this whole Article 7 is about your rights as a copyright holder and what happens in it and how the contract deals with who owns what. And it explains because even the use, like I said, in this case, the use of the drawings is illegal if they've been taken. You have to have a license to use that, and that's what we'll talk about this. So, Article 7. The architect and owner warrant that transmitting instrument services or any other information, the transmitting party is the copyright owner of such information or has permission from the copyright owner to transmit such information for its use on the project. Now here, they call it the transmitting party. By and large, it's going to be the architect transmitting its drawings to the owner, and the owner will transmit them to the contractor. Sometimes the architect will issue them directly to the contract. But the transmitting party is the architect. But it could be that the owner has some owner's consultants. That kitchen designer has a set of drawings, and the kitchen designer has given them to the owner. That kitchen designer owns its copyright, and as it says, they have permission from the copyright owner, so the owner of the project has permission to transmit the kitchen designer's copyrighted work to the architect to incorporate it. So it just basically says, I'm telling you I'm going to transmit these to you, but I have the copyright in that. That's the first level. I'm sending it to you, but I own them. Nobody else owns them. Second, 7.2. The architect and the architect's consultant shall be deemed the authors and owners of their respective instruments of services. So authors, you were the one that wrote it. Owners is you keep it, you own it. And they say respective instruments of services because what happens is when the architect submits the plans for the full house, the electrical engineers put in an electrical plan, structural engineers put in their structural plan, so forth. And the architect and its sub-consultants have their own agreement and licenses to use. And so everybody owns their own respective designs. That's 7.2. 7.3. This is how the owner is allowed now to use the drawings. Because like I said, if you don't have permission, you can't even use them. So the architect grants to the owner a non-exclusive license, meaning it's not just you, and sometimes you can have exclusive license depending on the agreement, but predominantly it's a non-exclusive license to use the architect's instruments of services, drawings and specs, or otherwise. But the owner can only use them solely and exclusively for purposes of constructing, using, maintaining, altering, and adding to the project. Not phase 2, not phase 3. So the architect, the owner comes and says, I'm going to build a high-rise building here, but I got extra land. I'm probably going to do a phase 2 in like 2 or 3 years, but just design me Tower 1. Built, done, architect gets paid, everything else. 3 years later, the owner's made enough money, gets the financing, starts to build phase 2. It's the exact same building, just right next door to it. Can't use them because that's not this project. The architect only has license the owner only has license to use the architect drawings only for this project, solely and exclusively for this project. And that's provided, obviously, that the owner substantially performs its obligations, like pays the architect for its services and so forth. The architect shall obtain similar non-exclusive license from its own consultants to make sure that you can use the electrical and the civil and the structural. And the license permits the owner to authorize the contractors, subcontractors, suppliers as well, and their own consultants to reproduce portions of the instruments of service subject to the protocols 1.3 for performing service to construct the project. So what happens is this here, so the first one says, architect gives the owner the license, gives a license to use, but only for the project. Second part says, architect, I am authorizing you, almost like my agent, owner, to then use and give my drawings to the contractors so they can use them legally. Because literally, anytime they open up the drawings and the contractor's using it to build something, if they don't have permission, they're violating the copyright. So this creates this permission in here. Again, it's only for this project. So that's your chain of command. Architect owns, grants a license, exclusive or non-exclusive license, but only for the project. That non-exclusive license allows the owner to give it to the contractors to build the project. If the architect rightfully terminates this agreement, you haven't been paid or some other issue, and you properly terminate the agreement, this license that's granted in this provision is terminated. So if you don't pay the architect, like happened with my lighting coordinator, and the architect is given those drawings to the owner, and the owner uses them to construct, and the architect's owed money, architect says, I'm terminating the agreement, you owe me money, and my license is terminated. You have no right to use my drawings. So it was under this provision that we went to court, and we said, we have terminated our agreement with the owner, they have failed to pay us, they don't have a license to use the drawings, stop the project. And the court said, based on the information you provided me thus far, I believe you, TRO granted. We're going to go to the rest of the litigation to find out if you're telling the truth and it's true. But since you, based on affidavits and otherwise, we believe you, so we're going to stop the project. Everybody, any license to use in any manner or fashion is gone. It's a very powerful tool. Somebody rips you off. So the other thing I will say, when I negotiate these provisions on behalf of the owner, I try to get the transfer of the license up front right away, and I get more of that. Sometimes I even say the owner owns the drawings. I'm paying you for this. Give me the license, and you transfer the license to me, not just transfer the ownership of the license to me. But architects push back on that. What I tell all my classes, and what I tell all the architects I represent, don't let them take your ownership. Give them a license. Say, I'll give you any kind of license you want, but I'm going to still own it, because that gives you big leverage when you're not paid. If the owner uses the instrument, this is 7.3.1. If the owner uses the instruments of service without retaining the authors, in this case probably the architect or the subconsultants, the owner hereby releases the architect and the architect's consultants from all claims or causes arising from such use. So I'm building phase 2, and I don't call the first architect up. Not only should I not be using those drawings, but if something goes wrong in that project and the wall falls down, even if it's the architect's fault, there's an argument to be made that I have released the architect from a claim. Even if the architect screwed up. There is a claim that the architect is making a defense that says, my drawings may have been defective, but you used them without telling me. And I possibly could have figured that out before that wall fell down. If you had me on the project site, because I would have looked at it differently, or I would have caught it in the field. I actually caught it in the field in phase 1. You just didn't know that, or you didn't remember that, or whatever happens. This is a release by the owner, so the owner can't say, your drawings were bad, ha-ha, I gotcha. Also, even more protective for the architect, it says the owner agrees to indemnify and hold harmless the architect and consultants for costs and expenses relating to causes of action, blah, blah, blah. What this says, this indemnification concept here, is architect and owner works together on phase 1, everything's fine. Architect doesn't get brought into the mix for phase 2. The wall falls down and injures a third party. As we all know from earlier discussions, that third party can sue anybody in tort. The architect can't point to the contract here and say, hey, I didn't have an agreement with the contractor or the owner on this one, so you, third party, I know you got hurt, I know my drawings were wrong, not my fault because the owner's released me. And he's going to say, or she's going to say, well, I didn't release you. It's tort. I can come after you, architect. Your drawings were incorrect. But the owner here, if they use that without the architect's permission, has to indemnify. Indemnification means, in this instance, that the third party, the injured party, should recover money, and it's deemed that it's the architect's negligent design, but the architect wasn't involved in that process. And there's a $1 million award. The indemnification says the owner has to pay that $1 million. Even if it's the architect's fault. Because it says, shall indemnify. Indemnify says the owner picks up the architect's tab. And hold harmless. I'm going to say to the architect, you are harmless in this, even though it's $1 million, because I used them without talking to you, without getting a license for them. I have to pay the bill for the third-party injured person. Does that make sense? Okay. (7.4) Except for the licenses granted in this Article 7, nor the license or right shall be deemed granted or implied under the agreement. So there's all other types of potential licenses. So this one's a non-exclusive license solely for the building, the project. This is where this will come up, an example of where this might come up. So instead of Phase 2, I want to do renovations to Phase 1. Or I want to do an addition to Phase 1. And I use those architect's drawings for that renovation or addition. There's an argument to be made by the architect, you needed to bring me in to do that design work for the renovation because you don't have permission. It is, I didn't give you this, even though it's still the project, your house, it's only to the narrow scope of that. I didn't give you a license plus. So whatever the license that we've defined in here, it's nothing more. The other where it will come in, the other area it comes in is owner and architect entering this agreement. The license is a non-exclusive license. Architect designs your house. You pay him. You love your house. You love the layout. Beautiful, et cetera, et cetera. And then 4 years later, you're driving down the road and you're visiting some people and you're like, oh my gosh, that's my house right there. It's the exact same house that the architect designed for somebody else in the other neighborhood. Since it was a non-exclusive license, the owner can't come back to the architect and say, you just designed and put my same house there. I don't want people to have my house. Now you have two of them out there. I wanted mine to be unique. And the architect says, I give you a non-exclusive license, meaning I can use it elsewhere. If you wanted an exclusive license and I can't use your design anywhere else, we should have negotiated an exclusive license. And the only use of my drawings can be on your house. Now, you can't use them for Phase 2 or you can't use them for additions, but at least I can't use them for somebody else. So that's why it says it's only the license granted or implied under this agreement. Non-exclusive versus exclusive would be an example of where a problem will come up. And then also here, another good provision for the architect who says, the unauthorized use of the instruments and service shall be the owner's sole risk, and without liability to the architects and the architect's consultants. Buyer beware. Question?
So when, let's say that there's an addition being done to a project, can the new architect use the old plans to see what was done in reference like the new addition is being done to a separate part of the building, so it's not like...
Let me see if I can figure out your question. So owner designs a house, builds a house, or the architect designs a house for an owner. The house is built. And then 8 years later, the owner wants to put on a kitchen addition, like I did. Can the new architect use the original architect's designs for that kitchen addition? The answer to that question is two parts. One, obviously go back to the contract, but let's say we're using this document, this AIA document. Depends on what the new architect is using it for. If the new architect is using it to make an addition and add to it, and there's no modifications of the original design, everything else, you would make the argument that the new architect can use that for references. Because, and this is what we did. I mean, I actually called the architect for the house and asked if we could use them, and he sent me a copy of the plans. He's like, fine. But at the very least, what happens is, because the way the addition was, the contractor and the architect that we hired could have gone out there with tape measures and figured that all out, and could have chipped away the drywall to find out where the conduit was. And so they could have done that all on their own to figure out where things were located, and that would have been more costly. So they're using it for informational purposes to expand, and that was not a violation of the copyright. They weren't using the plans there for another house they were doing. So my architect, when they were finished with designing our space, gave me back the old architect's designs and didn't take anything from that. So yes, they can use that. Now, if there is something greater going on, where they start relying on certain design elements, let's say that there was a cantilevered system that was coming out, and they started basing it on some of the designs that the original architect had used, and relying on those things without communicating with that architect and without checking what's in the roof or the guts of the building. There could be an argument made that they were using those drawings and potentially infringing on it, and the architect can say, the original architect can say, hey, you didn't come to me and talk to me about the beam and the common beam structure and whether it could have supported and how I had designed that. And so if the wall falls down, figuratively or literally there, it's not my fault because you didn't have the authorization to use my drawings or the representations that were made in my drawings. Does that make sense? Okay. All right, so they can't have any other lights, and then the other authorizes the owner's sole risk. 7.5, the provisions of this Article 7 shall survive the termination of this agreement. Now, agreement terminates on two ways. One party says, I'm going to fire you, or I quit, I'm not going to work, so it's terminated by an action before the project is finished. Or, when the project is completely done, the agreement itself, the contract just kind of ends. It terminates on its own, by its own time frame. But this concept of ownership of the copyright, we specifically say, survives the termination of this agreement. You build, you pay the architect, you successfully design and build phase one. Everything's good. It's fine. It's dandy. 3 years later, well, that first contract is now ended. Or maybe it's 5 years later or 10 years later. That has ended. And the owner then uses the drawings for themselves. The owner can't say, statute of limitations says it's outside of the 4 years. Remember we talked about statute of limitations? It's outside of the 4 years. This contract has been expired. It's terminated, so I can use your drawings. No, because this provision says it has a life of its own. I keep the ownership rights of this copyright outside of the four corners of this contract. Article 8, claims and disputes. So, things can go wrong, so now we've got to figure out how people pay for it and what happens. 8.1.1, the owner of the architect shall commence all claims and causes of action against each other, whether in contract, tort, or otherwise, within the period specified by applicable law, but in any case not more than 10 years after the date of substantial completion. And then the owner and architect waive all claims and causes of action not commenced in accordance with this section 8.1.1. So the first part says, okay, if we have a problem with each other, we have to start this claim. We have to do it in accordance with the law. Applicable law would be the state or the location where your project is typically. Not always. Sometimes you may have a construction contract that says we're building in New Jersey, but it's under the laws of the state of Illinois. If the parties have agreed to what the law is, even if it's not where the project is located, that becomes the applicable law. So for our example here in Illinois, as I just said, the statute of limitations for a breach of contract action, a claim, is within 4 years of when you knew or should have known. So this provision says if you're going to make a claim against us, you got to go by the Illinois statute of limitations, 4 years of when you knew or should have known. But if you also remember when we talked about statute of limitations, There's in Illinois what's called the statute of repose, and you have 10 years before you knew or should have known. And so my example was, let's say that the architect designed a ceiling, a leaky roof. You didn't find out that the roof leaked until 9 years, 364 days, but it's within that 10 years, and then the roof leaks. So now you should have known. You get another 4 years after that. So in Illinois, it could be up to 14 years long before that claim is obligated to be brought. So what this provision says is, got to do it within the period applicable, but no more than 10 years. So if you're an architect and you sign this agreement in the state of Illinois, your 14 years has come back to 10. Does that make sense? Okay. And then it says, if you're outside of this period of time, you waive all claims. You can't bring it. So this is kind of supporting what the statute of limitations concepts are. Obviously, when I represent an owner in Illinois, I cross that 10-year statute out. Just to make sure you get the whole 14 years if you represent the owner. In other states. A lot of states, the statute of repose and the statute of limitations are the same. Illinois is really confusing. They have just two of them. So like if you're designing something up in Minnesota, it's 6 years. And I think in Michigan it's 5, but it may be 6, no matter what. It's like 6 years when you knew or should have known, or 6 years of when it happened. It doesn't matter. Just 6 years. No 4 or 10 or 10 plus 4 or any of that other stuff. It's just 6 years. And so for this provision, if it's just 6 years, it would only be by applicable law. It doesn't even go to the 10 years. But they want to have a cap of 10 years on this no matter what. That's what they try to do. 8.1.2, to the extent the damages are covered by property insurance, the owners and architect agree to waive all rights against each other and against the contractors, blah, 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 except for what's rights and such they may have in the proceeds of insurance set forth in the AIA document, the A-201 2017. Now, this is a new provision in this agreement because by and large, the AIA documents have not, in my opinion, have not covered insurance adequately. It's not from a lack of trying, and it's not from a lack of intelligent attorneys and everything else. It has to do with the insurance industry is a moving target. It is very much dictated and mandated by market forces and insurance companies as one of the most lucrative and successful business entities out there in the country change their policies all the time. So the architecture, AIA documents or any other form document, especially if the document's around for 10 years, there's no way that their insurance language will remain viable for the full 10 years. That being said, they came back, the AIA, and we'll talk a little bit more about this for the A201, they came back this year for the 2017s recognizing that insurance, the world, the market changes. So they created a different format of how they require insurance. And it's they offer suggestions of types of insurance. They have this exhibit that has kind of a laundry list. You can check the boxes of the types of insurance. So they don't get into the granular. They just get in the bigger area. So that's what's nice about it. And I think hopefully it'll work better as a form document. So what this provision says is if there's property insurance out there, that goes first. And we're going to waive each other's claims against each other because we're going to have the property insurance pay for it. Except and unless some of that stuff that's in the laundry list of insurance on the contractor side, if that picks up, we'll let that come in as well. So this is an insurance provision that tries to say, basically it's saying, what bucket of money do the parties need and should use first, second, and third to pay for whatever claims and losses exist? And one of those buckets of money could be the owner's or the architect's professional liability insurance. Second, 8.1.3. The owner and architect waive consequential damages for claims, disputes, and other matters in question arising out of or relating to this agreement. So in the damage world, if you remember from our damage lecture, there's direct damages as one type, and there's what's called indirect or consequential damages. So indirect or consequential damages may be that toy factory doesn't open on time, and there's lost sales. Well, consequential damages could be as a consequence that the factory didn't open on time. We've lost sales. But then the next level from that is the owner of the toy factory would have made 15 cents profit on each of those sales. Profit for sure would be a consequential damage, and they have waived them here. I'm not going to get into a lot of great detail of how consequential damages are delineated and figured out because there are treatises and tomes written about it. It's a very highly debated subject of what it is. But understand here that the only damage claim that can be recovered between an owner and an architect are what directly arrived as a result of the breach of contract. So if it's a delay for the project and you had to spend more money to get it to the end of the project time, you get the delay damages. If the wall fell down and you had to spend more money to build the wall back up again, you get the cost to build that wall up again. But you don't get the 10 cents on every toy that wasn't sold because the factory wasn't open. That's a consequential damage. Same thing for the architect. The architect says, Mr. Owner, you didn't pay me and you didn't get me this stuff timely, and we thought we would be finished with this design work in 6 months. Now it's 8 months, and as a result of that, I lost 2 other projects because I guaranteed my team members. I guaranteed the best team possible, and I got stuck because we were on the project for 3 months too long. So I lost 2 other jobs, and I lost $100,000 in profits from not having those 2 other jobs into my shop. That's a consequential damage, and the architect cannot recover those lost job and the lost profits on that. They can only recover the extra cost to pay their workers to be on the project for 3 more months. 8.2, mediation. One of the things that's nice about the construction industry is they recognize that as good as us, as the lawyers that we are, and as great as I'm going to do a job for you, we are really expensive, and litigation is very, very expensive. So they use what's called mediation, and it's mandatory under the AIA documents, and I think it should be mandatory in every construction document. Mediation is a non-binding business resolution. Now, you present legal arguments and you put in you don't really put in evidence, but you present facts to the mediator and you talk about why you would win if you had to go to court and everything else. But at the end of the day, the mediator has no power to make one party pay over the other. It's a third-party neutral, but that person is trained in negotiating between disputing parties. So it's non-binding business resolution. Under the AIA documents, under 8.2.1, any claim or dispute, another matter in question arising out of a related disagreement shall be subject to mediation. So you got to go to mediation. And then the architect may proceed in accordance with applicable law to comply with lien notice or filing deadlines. So if there's a lien, you may have to do some other stuff because that's not you can't do a mediation with liens. But other than that, everything else under this agreement needs to be mediated. 8.2.2, they shall endeavor to resolve all claims and disputes and other matters and questions between them by mediation. So this is bringing the architect into it. And shall endeavor means you got to do your best effort. You're going to jump in. It doesn't mean that if it's not resolved by mediation that we're done, but it says you shall endeavor to do that. And then this goes through and talks about how much time, but it also puts here, the mediation shall proceed in advance of the binding dispute resolution proceeding. So you got to have, under this agreement, you got to mediate before you go to court, or you got to mediate before you go to arbitration. Now you can tweak some stuff, and they have some other things that if let's say, sometimes some people use it as a stall tactic. Owner and architect get into dispute. Architect says, let's go to mediation. Owner says, sure. And then they stall, and they stall, and they stall, and they stall. Architect doesn't get paid. At some point in time, and it talks about here, 60 days, there's other provisions that talk about this. If the parties aren't getting to a resolution in the mediation, they're not moving that process forward, the architect can then, or whoever's bringing the claim, can then jump to the next level, arbitration or litigation. So it's not an indefinite stall tactic that can be used. 8.2.3 just says sharing of fees. Everybody, you've agreed to mediation, so now you're going to agree to split the cost. 8.2.4, now we haven't figured out. We haven't been able to solve it by mediation. So then they say, well, we're going to figure out what's next. What's the next step if we can't do this by mediation? And what this is nice is the parties have to agree long before there is a dispute. Do we want to go into arbitration? Do we want to go into litigation? Or they have other. And other could be, there's all these conglomerations about different types of facilitative mediation or meet-arb or arb-meet. There's all these kind of different animals of how you can dispute resolution. Flip a coin, whatever you want to do. But here, you have to decide at the beginning of the contract, if we can't get through mediation, the next step shall be X. And that way it allows people to make sure they timely file with the courts or whatever has to happen for that. So that's what 8.2.4 is. If you have elected arbitration, 8.3 talks about how arbitration goes. So if they've selected arbitration as for binding, and remember arbitration is binding resolution, it shall be subject to which, unless the parties mutually agree otherwise, it shall be administered by the American Arbitration Association in accordance with the construction industry arbitration rules. And there's a set of forms and rules that the American Arbitration Association, the AAA, puts out. This is the most widely used arbitration organization in the country. But there are other rights or ways you can do it. You can use other people's arbitration rules, but predominantly they use the AAA here. And there's a specific set of rules they have to follow. It talks about filing fees and powers and timing and everything else in the AAA's rules. A demand for arbitration, 8.3.1.1, shall be made no earlier than concurrently with the filing or request for mediation, but no event shall be made after the date when the institution of legal or equitable proceedings based on the claims of dispute or other matters and questions would be barred by the applicable statute of limitations. So, when an architect gets into a fight, architect says, you owe me $50,000. Owner says, no, you screwed up, your project was delayed, I'm not paying you, you rat bastard, whatever you want to say. Architect says, I demand mediation. They can also file at the exact same time a demand for arbitration. They can file that with the AAA and start that process going. Now, the AAA is going to ask, are you guys mediating? Yes, we are. And the AAA say, I'm going to hold till you're finished with that. But they can file that demand right away. But the second part of this says, you need to file because it's binding within that statute of limitations. So that 4 years in Illinois you knew or should have known, or the 10-year plus 4, up to 14, whatever you fall into the category, you have to abide by that. Even though you're not going to court, the arbitration can be dismissed if it's outside the statute of limitations. And I've done that. I've had an arbitration filed against my client. There's a couple different processes, but the first process is you actually go to the AAA and you are appointed an arbitrator and you say that this is outside of the statute of limitations. A second way you can do that is you can go to court and you can say, this arbitration demand was filed. It is not timely. It's outside of the statute of limitations. We want the court to rule. And what will happen there is the court will either rule on the facts presented or the court will say, go back to the arbitrator, have the arbitrator make the finding, and then come back to me and I'll enforce that arbitrator's finding. But in either instance, that court-driven statutory statute of limitations is applicable to this AAA arbitration, even though you're not dealing with judges or juries. 8.3.2, there shall be enforceable in accordance with applicable court having any jurisdiction thereof. So that's what it says. So let's say you get to the end of the arbitration, and the arbitrator says, I award architect $48,000 of the $50,000 claimed. The architect can take that award, go to the court, and file it. And then that's a judgment in law. And if the owner doesn't pay that $48,000, the architect can get a sheriff to go out and replevin or whatever the action they might want to do to try to get their money from a court of law. So the court of law can enforce that judgment. I've also had that. Claims a much higher dollar figures, but in the millions of dollars, and you want to make sure that they don't skate out on them, so you go to court. And then the award in arbitrator shall be final. That's the one bad part about arbitration. You're done. There's no appeal. It's just finished. Whatever the arbitrator panel says, you're done. There's just very few minor areas for appeal, like if you find out that one of the arbitrator panels, their sister's married to the owner of the other person on the other side. If there's some undue bias. But if they screw up in the law, this is the worst thing about arbitration. If there's an error in law or an error in fact by the arbitration panel, they just completely blew the law, or they completely blew who the facts are, it is not appealable. You're stuck with it. So that's one of the problems with arbitration. It's faster, it's cheaper, but you're stuck. You don't get the appeal. 8.3.4, consolidation or joinder. Basically what this says is, if the architect sues that owner for $50,000 for the fees, the owner says, you know what, I don't think I owe you anything, but I think that there was problems with the rest of the project and everything else, and I want to bring in, and I have problems with the contractor. I don't want to have two lawsuits. I don't want to have one going here and one going here. I'm going to bring the contractor in, so we're going to have everybody at the table. So everybody's at once. So that's what consolidating and joining part is, consolidation and joinder. So if everybody kind of has the same substantially or similar fact scenario, I mean, if the architect's talking about one part of the project and the contractor's claim is a totally different part of the project, you wouldn't consolidate. But if they're similar and have the same set of facts and it's more economical, this recognizes that you're allowed to consolidate and join in arbitration. The basic reason why they do that, besides the economy, is in the law you can do that. You can bring somebody into your lawsuit. So why not do it in arbitration? This continues talking about a common question of law, provided the party can be joined consent. So you have to have, the contractor has to have a similar consolidation or joinder agreement that you have with the architect. So again, inconsistencies of your contract documents, make sure they have the same thing. I had a project where the original owner-contractor agreement was mediation litigation. Then about a year and a half into the project, the owner got a big donation for a portion of the project, so they could actually pay for it to construct. And the party that got the donation, that gave the donation, they got their name on the park and everything else, required that any disputes arising out of the construction of that section that they put money in for donation must be resolved by arbitration. So now I had inconsistent provisions. I have a litigation with the owner-contractor, and I have arbitration with owner-donor. Luckily, nothing happened with the area that was built, but had there been a lawsuit over that, and I told the owner, this is what happens, and I'm like, yeah, but we just got $20 million from them, so I'll suffer through, they would have had two lawsuits pending, or they would have had arbitration pending and a lawsuit pending at the same time. And they could have had inconsistent results. You could have had the arbitrator say, not contractor's fault, or the court say not contractor's fault in the litigation matter, and the arbitrator saying it is the contractor's fault, but because they weren't similar provisions, they can't be joined. So it just depends on what happens. And then also 8.4 says that this provision will survive the termination of the agreement, just like the copyrights. Any questions on claims or disputes? Okay. Article 9, termination or suspension. 9.1. Pretty simple. The owner fails to make payments to the architects in accordance with the agreement. Such failure should consider substantial non-performance, cause termination, or suspension of the performance of services. Basically, it's like, hey, you haven't paid me, I can stop working for you, or I can just terminate the agreement. The architect elects to suspend the services, they should give the owner 7 days written notice. You can't just stop working, you got to give the owner a chance to pay. And then before resuming services, the owner shall pay all sums due, so you owe me that $50,000, pay me before I start up again, prior to suspension, and any expenses incurred in the interruption. While you're negotiating that $50,000 payment, the architects are sitting around. They're not working on other projects. They may be on the site. It may be a project that's where they have to stay in a hotel. Who knows what happens? Any of those costs and expenses during that delay, the owner has to pay those as well. Salaries, whatever that might be. So even though since the architect has stopped working, suspended, that doesn't mean the architectural firm or the people that were working aren't incurring costs and fees. And then the architect's fees for the remaining services and the time schedule shall be equitably adjusted. So the architect said, I'm going to promise you that I'll get your drawings all done by 3 months. There's a 2-week delay in the project because of the failure to get paid. When the architect worked through, owner pays the $50,000 to the architect that's owed. Owner pays another $15,000 for expenses. Architect will also get a 2-week extension on the schedule. I don't have to have the drawings finished to you by March 31st. I get till April 15th. That shall be equitably adjusted. There's no may, it's shall. If the owner suspends the project, sometimes they have financial issues. Sometimes they have timing of delays of when they need to have the project finished, whatever it happens. So this is the owner suspending, as opposed to the previous one was the architect suspending because they were paid. The architect shall be compensated for the services performed prior to the suspension, everything did after that. And when the project is resumed, they shall be compensated for the interruption of the architect services, so just the same thing. So in this case, the owner made the decision, but the architect still gets paid for that time off and time for resuming and getting back up to speed. 9.3, if the project is suspended for more than 90 cumulative days for reasons other than the fault of the architect may terminate the agreement. So it's not a question of the architect not getting paid. He's paid in full. Everything's fine. The owner calls up the architect and says, you know what, we've got some cash flow problems. We're just going to shut this down for a little while. Day 91, maybe the architects read some things about the owner in the news. Maybe they don't want to continue. Maybe they need to use that crack team on a new project. According to this provision, the architect can terminate it by 7 days written notice. They write the letter on day 91, and on day 98, they can walk away. The owner can't come back and say, well, wait, that's a breach. I need your team. I need to do this. I'm going to start up in like 2 more months or a month, or I'm just about there. The architect doesn't have to wait. It's 90 days of a cumulative suspension. So it's not consecutive. It's 90 days throughout, even that. Stop for 45 and back on, stop for 10, whatever it is. The architect's allowed to walk away. You're too risky. I need my team elsewhere, whatever the matter might be. As long as the architect gives 7 days written notice. 9.4. Either party may terminate this agreement upon not less than 7 days written notice. You always got to write that letter and give them 7 days. Should the other party fail substantially to perform in accordance with the terms of the agreement and through no fault of the party initiating the termination. So, obviously, under 9.1, failure to pay, they've already deemed that as a substantial failure to perform. But there could be other things. The owner continuously and repetitively fails to provide information in a timely manner. So the schedule is just getting blown out and blown out and blown out. And the architect's like, I can't do this anymore. You got to give me information, or you're refusing to give me information. I'm giving you 7 days termination notice. Or the owner says to the architect, you haven't given me the drawings timely. Or the drawings have to be revised, or the budget, every time you give me a revised budget, or revised cost of the work, it's outside the budget. So those are reasons for termination by the owner side. Traditionally, an owner, and this is something you'll see probably very common when you start practicing on a regular basis, they will change 9.4 to say that the architect, this is either party for substantial breach. They'll change this to say, the architect can only terminate for failure to pay. That's something you'll see often, as opposed to substantial breach by the owner. But in here, it's equal. It's a equally weighted provision under the standard form. 9.5. the owner may terminate the agreement on not less than 7 days written notice for the owner's convenience or without cause. So the architect doesn't even have to screw up. The owner can just say, I'm done. Now, the architect can't terminate for convenience. The architect can't say, I really don't like you. I'm tired of working with you. You're out. But the owner can. The reason why is because the owner has the money. But if you terminate for convenience, that's what 9.6 says, the owner shall compensate the architect for services performed prior to the termination, so pay me up to the date when you said you didn't like me anymore. All my reimbursable expenses, so all my photocopying and stamps and mileage and everything else, pay me all that, and all the money I owe to my subconsultants, my civil engineer, my electrical engineer. Cost attributable to termination, I had to relocate people. They had to stall out. So that's kind of, one would argue, cost attributable to termination could fall kind of into this area of consequential damages, but since it's specifically identified here, you're allowed to recover it. And including the cost attributable to the architect's terminations of the consultant's agreements. So what's this last part mean? I have an agreement, I'm an architect. I hire an electrical engineer. It's a very sophisticated project. And they need to crack the best electrical engineer in town. And not surprisingly, that electrical engineer is completely overloaded and has everything else because they're so good. But you need it for the project. High-end stuff, low voltage, all the stuff that's in there. You really need this team. That engineer says, okay, fine. I'll come work for you. I'll do this. But if the project is stopped, you got to pay me a termination fee, a one-time termination fee of $10,000. You got to pay me everything I did up to this point and a $10,000 termination fee. It's a one-time payment. Owner then says to the architect, it's not because the architect is screwed up or anything else, there's just a difference in opinions. I don't like you anymore. I'm terminating you for convenience. Architect says, okay, here's what you owe me to date. Here's what it costs for my reimbursable expenses. And here's this extra $10,000 kicker to get out of this super-duper contract with my electrical engineer. Because of this provision, including the cost attributable to termination consulting agreements, owner has to pay that $10,000 kicker. Because that was the cost to get this super-duper electrical engineer. The owner could argue, the owner could say, but I didn't know that. You didn't communicate that to me. And it's like, well, but we didn't have to necessarily. You wanted the best of the best. That's what our discussion was. Now, there may be a fight whether it's fair and reasonable and everything else, but under the black letter reading of this provision, that $10,000 termination fee between architect and electrical engineer is paid for by the owner because the owner just said, I don't like you anymore. The owner terminates his convenience pursuant to section 9.5, so that's what we just talked about, or the architect terminates the agreement section to 9.3, the architect shall pay the architects for the following fees. And so this is new in this provision because there used to be fights over what was termination expenses and everything else. And the first one was the termination fee. There may be a flat-out fee between the owner and the architect. And the second one is, I'm terminating you for convenience, the owner says that, or the architect is terminating under 9.3, if we want to go back real quickly to that. 9.3 is the suspension. So nobody did anything wrong. The owner just was stalled out. And he had to get financing. And the architect wanted to move on. So in either instance, the owner terminates for convenience, or the architect terminates because it's too much time. The owner still says, but wait a minute, now I'm back up. I got my money. I still want to build this building. If you take the drawings from me, I got to go start from scratch. The project's halfway through. I need to use those drawings. But remember, it's the termination of the agreement. And that license back in Article 7 says the license doesn't survive the termination of the agreement. So they had to reconcile that. So the AIA said, hey, if there's a termination for non-defaulting reasons, non-nefarious, the owner wants to continue to use those drawings, they will pay a one-time licensing fee to the architect. The architect's out, but I get a license fee to use those drawings to complete my project. And that's fair. Because to require the owner, if they had some financial problems and the architect said I wanted to go elsewhere, they require the owner to start from the beginning, that would be just a financial devastation. So the owner can use those drawings going forward. And the architect's protected because the owner still has to indemnify because the architect's not around if there's problems with it. But they get to use it. So it's a balance for everybody else. And the architect gets paid for it. They get a licensing fee. They get another chunk of money for that. And the architect, they can negotiate what that fee is. And then 9.8, except as otherwise professed in this provision here, the agreement terminates 1 year after substantial completion. Remember I said the agreement kind of dies on its own. And that affects some of the other provisions where they say this provision survives the termination of the agreement. Any questions on those? Article 10. Miscellaneous provisions. The catch-all. 10.1. It's governed by the laws of the place where the project is unless stated otherwise. If the parties have selected arbitration as a method of binding dispute, the Federal Arbitration Act shall govern Section 8.3. And there's a whole set of rules of how the Federal Arbitration Act is applied and everything else. So you use the AAA rules in conjunction with the Federal Arbitration Act, and that's what everybody follows. 10.2, terms of this agreement are the same that we find in the AIA 201, that consistency of terminology. Cost of the work in one document is the same in the other. Project in one is the same in the other. 10.3, the owner-architect respectively bind themselves, their agents, successors, as signs, and legal representatives to this agreement. So it's your basic language to make sure that the agency world is working. We all understand. If I designate a representative, if they designate a representative, they're my agents. Everybody's bound, just like we talked about earlier this semester on agency theories. 10.4, certificate language. What's this? These are just certifications on pay-ups so that they have to certify within a certain period of time. But don't worry about that for the exam. 10.5 says nothing in this agreement constitutes a contractual relationship, cause of action in favor of a third party against either the owner or the architect. It's basically saying the contractor but anybody else. So architect has agreements with other people. There's not a contract between architects, consultants, and the owners. Owner has agreements with other entities, contractors, tradesmen, other consultants, other designers. They're not looped in. So it's just, this basically says this agreement is only between owner and architect, nobody else periphery that's related to the project. 10.6, this is a good one for the architect. You do not, as the architect, shall not have responsibility for the discovery, presence, handling, removal, or disposal of, or exposure of persons to hazardous materials or toxic subjects at the project site. As I said, there could be contamination. A lot of times there's projects. When I work on some of these large power plant projects, they have certain, at the plants for the operations of their systems, they have certain highly volatile chemicals that are used for cleaning things or what have you. And in fact, a lot of times I'll go on project sites with the hard hat and the steel-toed boots and walk around the project sites that I'm there to inspect as a lawyer. Architects are there as well. I have to go through a safety training class. I actually have to be certified under OSHA and other things of what happens if this ammonia is released because it's deadly, some of these toxic substances. But even if you're digging in, like let's say you're working on a project site and it's a Superfund site and you dig in, you find that. Or I had a project out in, I'm blanking on the name of the city, Streeterville, Illinois. And they were digging and they found an old oil tank that people had used for a boiler. And so then there was an oil leak. So there's all these things that can happen, toxic substances. Contractor and owner are typically responsible for that stuff. Architect specifically is not. If it's on the project site, it's handled by somebody. If it exists there or if it's removed or anything else, architect says, I have nothing to do with that. The only time the architect is ever going to be responsible for that is there are sometimes architects' designs require the implementation or use of toxic materials because of the way the structure, actually it would probably be more of an engineer depending on what's being designed and installed, like some part of a pump or what have you may require that. They'll be responsible for those obligations. But other than that, no toxic substances are tagged to the architect, period. 10.7 just says, hey, if I want to take photographs of my project when it's done, I'm allowed to do that. You can't tell me I can't. I can use it for representations. But then it goes, the owner's like, and this is, again, a general provision. The owner says, okay, that's fine, but you can't use my confidential proprietary information, so you can't publish maybe my name. You can't maybe necessarily publish the financials of what we're being paid for this project. That's confidential. There may be areas in a project site that are they're proprietary or confidential. Like if there was near my office is the Fed building, and a number of years ago there was a whole bunch of renovations. I guarantee you there is no photographs on the architect that designed the renovations. There's not one photograph on their project website because it's secret. It's in the Fed. You're not allowed to put that out there. So it's confidential here. And then it also requires here the owner shall provide professional credit to the architect and the owner's promotional materials for that project. It's like the billboard when you walk by and it says, like this, you guys have your construction project going out here on Harrison for the new student housing or whatever it is. My guess is on those billboards it's got the contractor's name and probably has the architect's name here. This provision is often modified. Sometimes the owner says, I don't want to have any photographs unless I get written permission first, or you pay me for them, or there's all different things of what you can do. But the basic model is architect can photograph, they can't release the secret stuff, and the owner needs to tell everybody that the architect designed this really cool space. 10.8, if either the architect or the owner receives information that is designated as confidential versus proprietary, the parties shall keep the information strictly confidential. Right? It's just an agreement. A lot of times it's the financial records of a company, but there are other things that can be confidential. You know, maybe you're designing a space for the owner for that new toy factory. And let's use a different example. Have we all, the Gene Wilder version, have we all seen Willy Wonka and the Chocolate Factory? Have you guys seen that? Okay, so, going in to see how the Oompa Loompas actually designed and made the chocolate, that's all proprietary. So you weren't allowed to bring in a camera and take pictures of that. You weren't allowed to talk about that. So the architect, granted, it was designed by Willy Wonka, but in the real world, if that was a factory was designed where there's secrets, and you take your architect to an existing facility to show what the space operates so they can design the shell for the new facility, that's business proprietary information. The architect can't leak that information out to someone else. When you say someone else, what do you mean by that? If someone else leaks it?
The architect working with someone else, or has someone under them who's not licensed, and they go on site and say something.
Okay, but so it's somebody employed by the architect?
Yeah.
Okay, that's a good question. So the question is what happens if the architect has somebody that's employed, either they're not licensed, I think is one of the points, and they're the ones that go out and leak the information. So, two answers. First of all, in the world of contracts, it's what's called typically a single point responsibility. So if I hire you as my architect, anybody you hire, whether it's someone directly for your firm or someone else that you hire to assist you, you are responsible for all of their actions. You are the single point responsibility. So if somebody that you bring in or somebody brings in their buddy to take a look, like this is a really cool project site, I'm going to walk you around. Anything that your company does or happens under your umbrella, you as the architect will be responsible for the other parties. That's the first thing. Second thing here is whether the individual that's doing this is a licensed architect or not doesn't matter. Licensing of architecture as a separate concept is so that they can practice architecture. We had the part lecture on whether it's a holding out or practice statute and everything else. So the licensure of an architect deals with the state regulations, but it doesn't dictate or mandate whether the contract and the terms of the contract are being enforced. They're completely separate. Because if you think about it also, roughly less than 50% of architects that are practicing are actually licensed architects. There's a lot of people that practice architecture for their whole life, but they are never licensed because they're working underneath someone. They never sit for the exam or otherwise. In fact, I think I told you the story about the woman that did the designs for our firm, and we were talking, and she recognized my voice because she had been listening to my tapes, and it was kind of unique. She's been an architect for 20 years, or maybe not quite that long, but at least 15 years, until she finally sat for the exam, and now she's licensed. But before that, she's a great architect, really good project designer, but she wasn't licensed. So those are two separate entities. Does that answer your question? Okay. All right, 10.8.1, if you have confidential information and then you need to release it, maybe there's a subpoena or some other thing that one of the parties has to release it, you got to give the party 7 days notice and they can come in. So this is just kind of what happens if a third party needs that proprietary or secret information. Well, the architect or the owner is required to give notice. Hey, I'm going to turn this over to the court. I'm going to do it in 7 days because I'm required to. And then the owner or whoever has the information must step in and do what they need to do. 10.9, this basically just says if something in this provision, in this contract is invalid or void or otherwise, we'll strike that one provision and everything else remains as is. There could be a change in the law that says, changes how statute of limitations work or change, the duties and responsibilities. So it basically says there's just one provision that's going to be stricken, not the whole thing. Article 11, how do you get paid? Compensation. We'll zip through this and then we'll get out of here. Basic services. Remember, Article 3 talks about the basic services, which is the design, structural, electrical, and mechanical. And you can be paid by 3 ways, of which I have stipulated sum twice, so I apologize for that. So one is stipulated sum, 2 is supposed to be percentage, not stipulated, and then 3 is other. The percentage one in 2 is, there's a chart in the AIA document, and it says we're going to figure out what percent is going to be paid based on the cost, or I'm sorry, not the chart. It's going to be percentage often based on the cost of the work. So that's what it has here. So I'm building $1 million house. I'm going to do the work for you for 10%. And if it turns out the house costs $1.5 million, my fee went from $100,000 to $150,000. So 2 is supposed to be percent sum. Stipulated sum is I'm building this house. I'm designing this house for you for $100,000. Period. The end. No matter what it costs, it's going to be $100,000, even if it costs more to build it. And then the last one, other. Sometimes you have hybrids. There's all different methodologies of parties can figure out how to do those over the course of time. 11.2, for supplemental services designated in 4.1.1 and any of the sustainability services required under that, they should be compensated as follows, and then you put in your definition of how much they're paid. That supplemental services, that chart that you, in 4.11, that you delineate who's doing what, and you negotiate that up front, and you talk about what the costs are for that. That may be separate from that is separate from your cost for the basic services. Additional services, that's what happens along the way that you may not have negotiated up front to do the work. You're going to be compensated, and then you put in the amount and basis of compensation to fill in the blank. Often a lot of these are hourly. In the profession, typically they're hourly. Occasionally you may have some lump sum, but most of the time for both supplemental and additional services, it's hourly. And then 11.4, compensation for supplemental additional services for the architect's consultants. How those going to be done? Typically they're going to be, okay, you have a civil engineer. Civil engineer sends you a bill for $10,000. You're going to pass that $10,000 upstream to the owner. But here, in 11.4, they recognize there's a markup here. Because if you have to pay the civil engineer and carry that $10,000 on your books, and you have to incorporate and have somebody roll that into your ledger that you're sending to the owner, you should get paid a markup for that. Typically it's 1% or 10%. So you get that $10,000 bill, you send that with the $10,000, put the 10% markup on top of that. This is if we're doing on compensation for basic services on a stipulated sum. So I'm going to do this project for $100,000. There's your $100,000 here. You're going to put that at the bottom, and it's going to be broken up. When I finish the schematic design phase, it's going to be worth 5% of the work, so you're going to pay me $5,000. When I finish the DD, it will be worth 15% of the work, so you're going to pay me $15,000. It'll all be based out of what your basic lump sum is. $11.6, when it's on a percentage basis, that was at 11.1.2, I had the error there. It should be calculated multiplying the percentages in the article by the cost of the work. So again, if it's as the project goes along, so it's $1 million house, you don't wait till the very end to get paid your 10% or your $100,000. Every time the contractor submits its application for payment, here's a $200,000 invoice. The architect bills 10% of that. So that's what this talks about that. 11.6, if something is deleted from a project for the compensation, then there's a renegotiation of how this is. And it's based on the lowest bona fide negotiated bill, or if no such bid or no such bid or proposal is received, the most recent estimate for the cost of the work. So sometimes the project will change, and it talks about how you recalculate how much the architect is going to get paid. 11.7, you want to tell them what your rates are. So later down the road, when you do get the bill hourly rates, you get here's what we charge. You'll just delineate those out. 11.8, this talks about what types of expenses are reimbursable. So you want to give them a definition up front. Hey, I'm going to charge you for my reimbursable expenses, and here's what they are. Transportation, long-distance services, printing, reproduction, postage. There's a whole laundry list here of what is considered reimbursable expenses. It's pretty standard. You'll see in the industry. It goes on. There's a dozen of them or so. And then 11.8.2, you get a markup of this as well. Again, if you're paying reimbursable expenses, if you're paying FedEx, you're paying the phone company or anything else, you have to carry that on your books, you get a markup for that. 11.3, this is if there's that termination for convenience. The architect, remember there was that licensing fee that says so you want to try to negotiate what that licensing fee is up front sometimes. So you say going in, hey, if you're going to use my drawings, here's it's $5,000 or $10,000. So you want to do that up front. 11.10.1, this is a down payment, just an initial down payment, you fill in that. And then 11.10.2, this is brand new because of the sustainability issue. And this says if you're having a sustainability certification as part of the sustainable objective, so if there's certain forms that the architect needs to fill out to make sure you've reached your objective, here's another fee. It's outside, remember, sustainability work is all outside of the basic services. 11.10.2.1, this is talking about progress payments. So typically you're going to get paid monthly as the project moves along. That means you guys are going to invoice monthly, and if it's on a percent complete, your payment's tied to the cost of the work as the project moves along. And then they say this part, amounts unpaid after X number of days shall have an interest rate. So this is just what happens if you don't get paid on time. 11.10.2.2, the owner shall not withhold amounts from the architect's compensation to impose a penalty or liquidated damages on the architect, to offset sums requested by paid to contractors for costs and changes of their work, unless the architect agrees or has been found liable in the amounts for a binding dispute resolution proceeding. Now, the first part, let me explain this, is kind of broken into two parts. The second part, I think, is going to be more relevant to you. So there's no such thing. You can't say as a penalty or liquidated damages, I don't like you, so I'm just going to withhold money from you as a penalty. You can only withhold money, arguably, for what your actual damages are in this case. Now, there could be liquidated damages, and that has to be negotiated, but for purposes of this provision, if something went wrong on the project and the owner believes it's due to the architect and the value of what went wrong was $10,000, the owner can't hold 10,000 plus 1 or $10,000 or $12,000 or $15,000 because, I'm going to have a carrying cost or I have this or that. The owner could arguably only withhold $10,000 because that's what his damages are. So that's the penalty or liquidated damages part. The second part is a provision that, as an architect, I strongly encourage you to keep in this agreement. So my example just now was there's a problem in the project, and as a result, the owner believes in the design the cost of the project was increased by $10,000. Contractor comes to the owner and says, hey, there's no way that if we build it the way it was designed, will it stand? We know that. It's not that the architect did something wrong, but we just can't build it this way in the field. I had a case like that where actually out in Navy Pier. So as you all know, Navy Pier sits out in the water. And they wanted the architect designed to put these big giant trees along the walkway there. It's not like there's any dirt under there. And they had these large, big pots that were put in. And structurally, the way the architect designed them just simply wouldn't have worked. It's not that there was a conceptual thing wrong, they just didn't have to do it, so there was a change. There was a change order. And the cost, because of all the trees around there, it was expensive. It was like it was maybe $300,000 or $400,000 to change each one of these giant pots the trees were going to sit in. Now, the architect argued, no, my design would have been sufficient. We thought it would work just fine. Contractor's like, there's no way, and we're not going to build the architect's provision. And the owner's like, well, we got to figure this out, but we got to keep the project going. So I'm going to pay the contractor this money to get the work done, and then we'll figure out whether the contractor owes me money back or whether the architect owes me money or what happens and how do we figure that out. Under the old provision and under the contract that I negotiated for Navy Pier, we were allowed to hold the value of what we think those redesign fees were back from the architect. And arguably, I told my client, you could hold the $300,000 and not pay your architect that. Now, we didn't want to get into a dispute with our architect and everything else, but we could have held onto that money for the cost of the change in the work and not pay the architect. This provision, however, says you cannot offset sums requested to contractors for the cost of the change in the work unless the architect agrees or has been found liable. So, you cannot, under this provision, that's why I argue the architect should keep this into your contract. The owner cannot, if the owner has a damage, in this case, my client did, we didn't figure out whose fault it was. The owner's not allowed to say, hey, I'm not going to pay you architect because it may be your fault. The only way under this provision that my client could have withheld that cost was after they had been deemed liable in a dispute resolution. So, we do go to 1250, right? That's what I thought. Okay. We're almost done anyway. So, do you guys understand that part here as far as you can? And that's a really good provision. You got to get paid what you're paid. And if the owner has some damages, figure it out later. Let's keep the project moving. Okay, special terms and conditions. This one's really easy. If there's anything else you want to add to the provision, you just stick it under Article 12 where there's nothing in here. And then scope of the agreement. This is just some more standard boilerplate language. It says this agreement is everything under the sun. There's nothing outside of the four corners of this document. That's what in 13.1 says. And then 13.2 talks about the provisions in this agreement is what this agreement's made out of. It's the B-101, the E-203, which is building information modeling, and then the E-204, which is the sustainability exhibit, and any other exhibit that are incorporated into the agreement. And I believe that's it. Yep. So, if you guys have any questions about the exam over the next week, just give me a call or send me an email. I'm happy to help you out with that. We will be in this room for the exam, and then I will grade the exams and have them finished. I'll send an email out for information on the pizza party, and then we'll go through, and I'll give everybody your grades in, and we can talk about it from there. All right? I'm sorry, how long is what?
How is the space of the exam set? Like, is it something where you have, like, standard time to think over each question, or is it one question?
Well, I mean, not knowing how long you are going through questions and whether people are looking at questions twice or three times, I would say on an average, you guys are a dozen. My classes have normally ranged between 20 and 30. I would say if there was 20 people in the classroom, at 12:50 there would be one or two people that were still working, but they would be looking at the answer 6 different times because they're like, is it B or C? I don't think anybody's finished the exam under an hour and a half, but most people will get done between 2 and 2.5 hours. So you should have plenty of time for it. Like I said, occasionally there's one or two people, but not even. There have been years where everybody was out of here by 2 hours. So, anything else? All right, we'll see you next week. So, anything else? All right, we'll see you next week. So, anything else? All right, we'll see you next week. So, anything else? All right, we'll see you next week. So, anything else? All right, we'll see you next week. So, anything else? All right, we'll see you next week. So, anything else? All right, we'll see you next week. So,